Okay, great. This is the accessibility as human rights session that we're going to do now. And we're coming almost to a very important part of the day and part of the Zero Conference. This session puts accountability at the center of our aim towards a zero barrier world. This is going to be quite exciting. So, as we all remember, the UN CRPD committee has issued a number of general comments on different issues. Who remembers? I'm not asking those on stage. Who remembers what was the sequence of the accessibility general comment? Was it the first, the last, the fourth, the fifth? Who remembers? Okay. Where are the lawyers? But we don't need only lawyers. This is our precondition. This is our lifeline. So the accessibility general comment was the second general comment. Yes, it was general comment number 2, which was issued in April 2014. And this is quite critical because accessibility is a precondition. It's not a technical add-on. It's not a policy option. It's rather a precondition, a prerequisite. It's not a favor that we ask. So with this amazing session to come now, it's not our ambition that we want to place. It's about our way of holding duty bearers accountable. How can we use the laws, the policies, to make sure that accessibility is delivered and translated into the life of everyone? And it's not only government, but it's also businesses and other actors who are accountable towards this prerequisite of having accessibility as a standard. So in this session, we will learn from the discussions how accessibility can be claimed, defended, and enforced. It's no more the ambition, it's now the action. Through the courts, through other remedies, including strategic litigation. We're going to go beyond the noise that we make on the media, but also using law enforcement mechanisms in place to claim our right to accessible world. We look very, very much forward to hear the experiences of defending, enforcing, and claiming accessibility. And we want you all to go back home with that energy of no more asking for a favor, but for the accountability of all duty bearers of the 193 state parties to the convention to deliver accessibility without any precondition. Thank you. Enjoy the session.
Thank you so much, Yeti, for this introduction. You gave us quite some high mark that we have to reach and have to live up in this conversation. We discuss, in a nutshell, it's about human rights, legal rights, and accessibility. This is what we are going to start with, and let's see where this leads us in discussion. And I hope we can raise these high levels of expertise and of knowledge to share that Yeti defined for us. Here with me to discuss human rights, legal rights, and accessibility are Carla Quattro. Carla was Canada's first ever minister for persons with disabilities. Ms. Qualtrough created a legislative and policy framework for disability, inclusion and accessibility in Canada. Welcome, Carla. To my right is Susan Scott Parker. Susan is an expert strategic advisor to a wide range of corporations and business disability networks worldwide, helping the global business community to make themselves, their products and services accessible, among many other things that she does. So welcome, Susan.
Thank you.
Oliver Lewis. Oliver is a barrister at Doughty Street Chambers, London. He's a human rights lawyer who focuses on the rights of persons with disabilities, both in the UK and a lot of other countries. Welcome, Oliver. So we will spend the next 52 minutes and 16 seconds exploring how to truly level the playing field between human rights and accessibility. We have 3 goals defined together jointly in a pre-discussion for this session. First, we will ask whether accessibility is a real right. Is it a legal right? What does a right actually mean specifically in legal terms when we talk about accessibility? Do I have a right to an accessible building? Do you have a right to an accessible conference or an accessible smartphone, and under what conditions? To keep this concrete, we will focus on accessibility in general and digital accessibility in particular, and not touch upon any other rights that are defined in the CRPD. Second, we will look at the legal and regulatory principles that govern accessibility. Together, we will examine the key international frameworks, above all, of course, the CRPD, but there's also the UN Global Compact for the corporate sector and the European Accessibility Act as a new achievement. We want to understand how these instruments, these international instruments, translate into binding national laws and actual enforcement. What can be taken to court? Is there a right to remedy that removes a barrier, or a right to financial compensation only for losses and extra costs? And how do legal standards work in practice? Do we have a clear codified rules, such as building codes and technical standards, or is accessibility defined case by case through court decisions, which will actually not lead to any substantial and permanent change? And third, and most importantly, we want to learn from our 3 panelists about strategies that actually work in practice to make the world more accessible. Our speakers have been selected very carefully, so we have jointly selected ourselves because they each bring a different dimension of the human rights perspective. Carla is a former minister who championed and enforced the Accessibility Canada Act as an example of good practice. Oliver has successfully brought accessibility cases before courts in many different countries, and Susan has worked with companies around the globe to make them and help them make their services, their products and themselves more accessible and inclusive. So, a lot of ado, but without any further ado, let's start this conversation. I would like to start with Oliver, when I'm finding the right page again. So, Oliver, let's start with the fundamental question. What do we have to understand when we talk about accessibility as a right? Is it a human right? What kind of right is it?
Really good question. So for the next 2.5 hours, I will describe and give a lecture on this important... Oh, no, I'm not allowed to do that? Okay.
No.
Okay. So really interesting question. Accessibility is seen in the CRPD as a legal duty on governments. It's not phrased in terms of rights, but interestingly, it's in Article 9, if you have the CRPD. But it's phrased in a way that states, governments have a legal duty to make the physical environment accessible, transportation, information and communications accessible in order to achieve a right. And that right that accessibility is supposed to achieve is the right for everyone with a disability to live independently and participate in all aspects of life. So that's important point number 1, that it's a sort of right. But in international law, it's a duty on governments which have ratified this piece of international law. And then second and final introductory important point is that the duty to create an accessible life world has a close sister, or maybe a first cousin, and that is the right to equality and non-discrimination. And a form of discrimination that is prohibited, that is not allowed, is a denial of reasonable accommodation. So while accessibility is seen as something that if you're an architect or a website designer or a person who's designing Vienna's tram system, you know that you're going to have some travelers and some people who are autistic, some people who are wheelchair users, some people who have visual impairments, etc., etc. So it's what we call an anticipatory duty, whereas the right to discrimination is something that can be claimed by an individual because they've been discriminated against because, for example, an employer or a person or a company that's providing goods or services has not adjusted something that would make that person with a disability be able to benefit from that employment or goods and services.
Thank you, Oliver. Before I hand over to you, Carla and Susan, for qualifying this question and giving your remarks, Oliver, just let me drill down one level. I don't know how many countries have ratified the UN CRPD right now, but it's 180 plus something. No? They have ratified this, and Article 9 is somehow part of their legislation. Does this mean anything in practice, or is it just the start of something?
Well, Michael, that's a bit of a presumption to say that they've implemented Article 9. There's incredibly patchy implementation of many of the CRPD articles in many countries.
Only the ratification happened, but if it stays with the ratification, there's nothing to take it from.
Correct, but ratifying the CRPD means that that country has promised to its own citizens and the international community that it will implement it. And interestingly, Article 9, the second part of Article 9 is gloriously bossy. So unlike many international human rights treaties, it tells governments how to implement Article 9. For example, promulgating minimum standards on accessibility, ensuring that stakeholders are trained on what on earth accessibility standards are, and providing signage in Braille, etc., etc. So it's very programmatic, operational, rather than staying at that policy level, which maybe that means it's more likely to be implemented.
Mm-hmm. Carla, over to you. Before we move directly into what you did to remedy the situation, when you started becoming a minister, you Canada had ratified the UN CRPD. How did you, as a minister, experience the situation, and what were your thoughts, and what were the suggestions that were made by your team and so on? So how did you experience the situation with Canada having ratified and not a lot happening?
Yeah. Not a lot happening being the operative phrase. So I was a human rights lawyer before I got into politics, and Canada has a very kind of robust human rights system. It's terribly reactive. You have to be discriminated against before this massive system kicks in and tells you that, yes, you have been denied this service, denied this opportunity, denied this housing, denied this job because of your disability or other protected ground. And what happened in Canada as a result of that really digging into this system is that we became very comfortable in the space of reasonable accommodation. So we know very well what we need to do, and what we think we need to do in Canada is make something work for somebody if the thing we built doesn't work for them. And it's very reactive, right? It's very after the fact. And what's happened is reasonable accommodation has become synonymous with risk assessment and with compliance. So what's happened is disability has become synonymous with risk assessment and compliance. And so we don't really speak the language of CRPD, we speak the language of our kind of national human rights legislation. And so what we wanted to do when I came into my role was really dig in on the CRPD, was really double down on Canada's commitment to the principles in the CRPD, the commitments, the legally binding obligations that we all thought in the advocacy space were very obvious, but it didn't feel like the system in Canada was responding to, because we fancied ourselves very well prepared on the human rights front to deal with discrimination once it happened, but not necessarily to avoid it or have any opportunity to stop it from happening in the first place. So that was kind of the way we approached our accessibility legislation, was how do we back this all up so we avoid discrimination in the first place, and what needs to be put into place to actually operationalize the CRPD, right? It had been 17 years, like we signed it in 2007, and it had been a very long time and not much had been done on the CRPD front.
Thank you, Carla. So Susan, what's your take on what is it a right or not?
Well, a right that isn't enforced doesn't feel like much of a right to me, first thought. I would remind us that the CRPD does not apply directly to the private sector. Also, interesting that Christopher Patnoe from Google yesterday pointed out when I asked him bluntly, does the word accessibility trigger in the minds of governments or the private sector the word rights? And he said he never hears the word rights in that context at all. And so we need to really up our game in terms of communication. And the people I would be interested in looking at in our conversation today are the regulators, the Equality and Human Rights Commissions in all our countries, who have failed to convey to anybody that actually failing to make the recruitment process accessible for a disabled graduate is discrimination. Just making it crystal clear. So if we could fix that by the end of this conversation, I'd be grateful.
Thank you. Well, I think we give it an honest try, because we got 3 different strategies here with me, with the panelists. Here it comes the legal implementation as a minister, here comes the legal implementation as a lawyer, and here comes the person working with the companies and the corporates. So we will explore these 3 different avenues, starting with you, Carla. So you gave already a wonderful presentation yesterday at the award ceremony, but still you provided a solution to overcome everything that we currently discussed with the Canadian Accessibility Act. So how did you do it, and what are the principles that this becomes a right?
Thank you. Well, first of all, as I said, we really wanted to unapologetically champion the CRPD in everything we did. And we wanted to, I would say, bring Canada along the journey of taking a human rights-based approach to life, to the things we do, the programs we design, the services we provide, the laws we make, the policies we implement. And we didn't talk about it that way within the halls of government. We didn't talk about disability or disability inclusion that way. So we were very intentional when we wrote the Accessible Canada Act to frame it around the language of the CRPD and the principles of the CRPD. So in the preamble to the law, we mention the CRPD, our Charter of Rights and Freedoms, our Canadian Human Rights Act, and then pivot into that's the framework. And then we're gonna to use the language of precondition. The things we're building in accessibility are the preconditions through accessibility, are the preconditions to realizing the rights that are within those kind of framework human rights documents. So we enshrined in the Accessible Canada Act the principles of the CRPD, so treating all persons with dignity, supported decision-making, and ensuring equality, fostering independent participation. And then we intentionally chose the language of the CRPD. So we enshrined in law a definition of disability that hasn't yet, but that will eventually be the standard definition of disability across laws in Canada. That's a massive amount of work to both kind of retrofit existing laws to make sure moving forward laws that refer to disability contain this definition, but it's there now in law. And civil society was very involved in coming up with the definition. It is very closely aligned with the UN CRPD's definition. That work doesn't need to be done anymore. We don't need to debate that right now. I mean, of course, will move forward, will always, it's evergreen, but, and then we systematically created a system within Canada in this law. Now remember, this is very young, and so it hasn't been fully realized, so we haven't gotten everybody there yet, but we do now have an accessibility commissioner within the Canadian Human Rights Commission. We do now have a chief accessibility officer within the Government of Canada, and we have a standards development organization. And those three components of this new system are intended to proactively identify and remove the barriers to discrimination, to ideally avoid it from happening, but at least take the onus off of the individual to fight the fights that they had been fighting all along. So what I would say, and I would say this proudly on behalf of the disability community in Canada, is I would say not every, but most of the major advances in disability rights in our country have been fought and won through the advocacy of the disability community, of our NGOs. It hasn't been because governments said, wow, you guys have all these rights and we're going to protect them and we're going to create this great system and laws. It's because people fought. And one example that I think is really important is when we patriated our Constitution in 1982 and created our Charter of Rights and Freedoms, the first draft of that constitutional document did not prohibit discrimination on the ground of disability. It just didn't include the word disability. And it was actually only at a parliamentary committee where disability rights advocates stood up and said, you have not included us in this foundational document for our country, that disability was added at the very, very end of the process, and thank God. But that wasn't because the government at the time said, you all have these rights and we need to make sure they're protected. It was because of the tireless advocacy of activists and advocates within our country. And we wanted to make it on the government. We wanted a system that made it the government's responsibility to remove barriers, and a Human Rights Commission's role would be then to make sure that that was done and that people had recourse that didn't involve individuals fighting these fights so hardly all the time.
Thank you, Carla. Anything that one of you wants to add?
Can I have one thing? Thank you. Thanks, Carla. That was so interesting to hear that. And the experience of Canada and other countries where people with disabilities and their representative organizations have been marginalized, forgotten about, silenced, not even invited to the room, those shared experiences from around the world led the people who drafted the CRPD, including many people with disabilities, to add a provision into Article 4, so the third paragraph of Article 4 places a duty on governments to closely consult and actively involve persons with disabilities through their representative organizations when developing and implementing any laws and policies to implement the convention. So that's a lawyer's way of saying that when we're talking about accessibility and creating the regulatory framework to ensure website and app digital accessibility or transportation accessibility, there is supposed to be, the CRPD says, a right for disability NGOs, disabled persons organizations, to participate in that, the process of developing such regulation.
And get paid for doing so, I hope.
Doesn't say that.
Okay, so this is one approach that that Carla showed us in as one of the, maybe the good practice in that area, the Canada Accessibility Act and the principles that were used and embedded. Let's put this on hold and let's look at another approach. Let's move to Susan and let's look what can and should happen also to make companies, corporates more accountable to see accessibility and live up to that as a right of people. There have been some regulations on an international base. One in Europe is the European Accessibility Act, and there's also something which is not a law, but it's also well regarded and worked with international business community. It's the UN Global Compact. So maybe Susan, you give as an introduction to those regulations and how they can build a framework for companies to be more accountable on accessibility?
I'm not going to talk in detail about the regulations, if I may, but as I look at what's happening with the private sector, and I stress public sector as employers and service providers, we focus on private sector, but that's not the entire game. I'm so conscious of the fact that we haven't told people that they have rights when and if they should acquire a disability next year. And so across the population of people in work, when you try to exercise your right of access, when you develop your disability when you're 45 and you've been with the company for 5 years, you have no idea what your rights are. And I keep coming back to why the regulators haven't made a general sweep of the population to say this is the world now. This is a human right. It's not a some human right. This is your right in the event you develop, I don't know, next week, next year, or whatever. And so there's a backdrop here that this is special treatment for special people and not many of them. But that we are seeing an increased understanding that working to the spirit of legislation, rather than focusing on compliance, is the way that clever business leaders now want to operate. Because, of course, the compliance culture says, I'm only going to treat you properly if I have to. And that's not a message that most business leaders would, well, admit publicly that they want to convey. Even more importantly, I think, is that when we see some legislation, some lawsuits coming through, we have to remember that this is where my legal advisor on my right can correct this. When you look down at what national governments do, the fact that there might be a European piece of legislation doesn't mean by any means that you've got a clear understanding of what it means and how to make it work in real terms in Spain compared to Germany, compared to wherever. We continue to overlook the negative impact of employment quotas, for example, which directly undermine everything we're talking about, and yet are expected to run at the same time in the mind of a business leader in Germany, France, or Spain. We are seeing some cases coming through. I mean, the French courts now looking at a claim in terms of against a major retailer because you can't shop online. The question for me is, why hasn't every association for the blind in every country in Europe starting to go down that road? And to pick up on what Carla was saying, we've also got the problem that recourse seems to be for an individual, one person going through. And we come back to the role of the Equality and Human Rights Commissions, which instead of advocating, let's take class actions through, as a Canadian, I don't usually look in that direction for guidance, but why haven't 1 million people who have visual impairment in Europe come together to say to their various regulators that we need to do something about this chronic issue within accessibility in terms of digital access to my rights? I guess the message for me here is, if you try to focus a company on legal compliance with inadequate national law, you end up with inadequate solutions. And that the more as a community we have clear messages about what the best practice looks like. Yes, you have to have standards, but they're never good enough in local building codes. So we do have examples of a company like GlaxoSmithKline producing a global standard to the built environment that they're confident lifts them above mere compliance with mere local building codes in every market in which they operate. So to be a little more crisp here, what I'm saying, I think, is we need to be much more clever at how we explain that the way to stay above risk, to mitigate risk, is to go well beyond what these inadequate local laws are requiring, while conveying the message that the world in which you do business is changing. Look at all this legislation starting to come down the line on artificial intelligence, on accessibility. An intelligent company has to be ahead of that and try to avoid dealing with their lawyers.
Thank you, Susan, but following up just simply on your...
You're going to say I didn't answer your question, is what you're going to say?
It was not exactly the question. Okay. This is why I'm asking another one. So you said, no, let's put it in another way. Could you be a little bit more specific on, I understood that civil society, DPOs, persons with disabilities have to come up and they didn't fully do their own job right now. What exactly would you suggest to bring forward to really create change? How to create this? Is it simply changing laws, or can they also use European Accessibility Act or UN Global Compact, or what tools would you recommend?
I think the anticipatory duty concept It worked quite well in the UK around customer access. So you have to anticipate the fact that you will have customers coming through with disabilities and ensure that they are treated, served on an equal basis. Perhaps we need to make more of that in terms of how this legislation is developed. But for me, if there are no teeth in the law, then it doesn't really matter how the law is structured. And so one thing that has struck me is time and time again, regulations or legislation is developed without the expert input from the private sector players who understand that piece of the business that the legislation is trying to get at. Not the lawyers, but the head of property. Not the lawyers, but the chief technology officer, sitting, working with civil society and regulators to say, we need legislation that is credible in the eyes of both business and people with disabilities, and unless it's got teeth, it won't be credible. When we brought 60 companies together in the UK in an alliance with the disability rights movement and the trade union movement, that was our key message. It stunned Maggie Thatcher's government that the private sector would be asking for more regulation, but they wanted to be able to manage it alongside race and gender, clearly, you know, as a rights-based, treating people properly to mutual benefit kind of situation. And because they were involved in crafting that legislation, it looked more promising. I still don't see the enforcement of the customer anticipatory duty. So I don't have the answer to that. I've got a lawyer here. Maybe he knows how to do that?
So let's ask the lawyer. You've already mentioned some cases. So let's move towards this implementing rights-based approaches on case-based. And also, Oliver, you also work in low-income countries. What about countries where the rule of law and human rights-based approaches are generally weak? What's your take on this?
If you're expecting an answer, then I feel there's a lot of buck passing to lawyers here going on, but you can do it. So I think there are several challenges, not just in low and middle income countries. Even in a country like the UK, why is it that we don't see lots and lots of litigation on accessibility? I think part of the answer is that it's very, very difficult to take these cases. Not only is it relatively expensive, but even if you find a lawyer who will work for free, to take a proper case, you have to have sufficient resources to immunize yourself against the costs risk of losing the case, and you have to pay the winning side, and the winning side might be a huge international conglomerate with very expensive lawyers who are going to litigate the case and defend the case really vigorously and spend a lot of money doing so. So that is a major problem. And another problem in the UK has been a weak regulatory infrastructure. So the Equality and Human Rights Commission in the UK, for example, hasn't, in my opinion, done anything useful in the disability rights space for a number of years. And it's they who really would have the resources to bring big challenges, but they just simply don't. In terms of low and middle income countries, what they might lack in wealth, they make up for in the incredible people resource that they have. And so I was in India last week, as an example, teaching on a postgraduate diploma on human rights and mental health. And the pavement outside the building that we were teaching in, I was there for 5 days, it had recently been just dug up and new cables had been laid, but then they hadn't bothered to put all the bricks and everything back onto the newly laid cables. So it was just a perfect example of things being not thought through from a disability, or not just disability point of view, but from a pedestrian point of view. It was just a perfect example of inaccessible walkway, and it's very, very difficult because for a number of different reasons. But one of the things I've learned from countries like India is that if one takes, rather than taking a kind of normative human rights approach to CRPD implementation, there are different approaches that you could take. So one of the approaches is more of a kind of public health approach. So low and middle income countries have made incredible progress in terms of things like maternal mortality, HIV, childhood vaccinations, clean water, access to toilets, and so on. And so human rights organizations are taking similar approaches to go out into the villages, and I've done a couple of these sessions some years ago in Indian villages where there were copies of the CRPD in the local language, summarized, and people were sitting on the floor talking about the CRPD. Whereas probably people in the government in Delhi knew less about the CRPD at the end of the session than those villagers did. And then they go to their local councillors, their local village governments and state governments demanding their rights. And I think it does, that is such a, something that perhaps we take for granted when we're at conferences like this, that we know we have access. If you're in this room, you probably have access to all sorts of things on your smartphone and on the computer in front of you. But we perhaps take for granted that, that just empowering people who are the so-called rights holders of rights is something that needs to be done deliberatively and can be done, and is in fact being done in Latin America, in Asia, in sub-Saharan Africa. So it all starts with the people and empowering people to know what their rights are, giving them some advocacy tools. But they have advocacy tools already because they have been advocating for better infant health or access to water, so on and so on. And this is something else in terms of not just accessibility, but other aspects of the CRPD that people are today and have been since the CRPD, and even before the CRPD, have been advocating for.
Oliver, I'd like to ask you one follow-up question. Could you give us one good example and one good practice of a case that went through and really improved accessibility? Might be one of your cases or one other that's well known in the community. In any country, just give us one example of, aren't there any that you want to use right now?
I can't think of any really fantastic examples of a legal case about accessibility that's changed some sort of system, because legal cases don't really work like that. Courts and judges are there to enforce a law. They're not there to make the law, and you go to a court when there's an existing law or regulation that perhaps has not been enforced or implemented, and you, the claimant, say, excuse me, judge, can you just say that this defendant has breached my rights under whatever provision? And each case will turn on its own facts. That's to say that there are very, very few cases where there are monumental constitutional or Supreme Court sort of decisions that change accessibility, that open out some sort of area of life that are accessible. And so the paradigm shift, which is a phrase often used when we're talking about the CRPD, the paradigm shift happens at very slow tectonic, it's the tectonic plates of society that shift incredibly gradually due to a number of different social factors, rather than going to court and expecting a sort of more, we're in an alpine country here, so an avalanche, right, that changed, something that happens immediately. So the law works, or the justice system works very slowly, but only incrementally. And if one wants a more immediate change in the system, then one has to do political advocacy, which Carla was talking about.
Thank you, Oliver. That is in itself already very insightful and helpful. Yeah.
And listening to that, I'm remembering the case study that looked so promising for us in the UK was we had a Disability Rights Commission for 5 years. Not an everybody, minestrone commission. With minestrone, there's celery in there, but you can't find it, right? So these commissions that pick up every conceivable aspect of human rights and difference and protected characteristics rarely really understand this disability rights thing. I'm sorry. If there's anybody here, I'm willing to talk about it. And so what would be really helpful if you're advocating at national level is to say at least for the first 5 to 10 years, you have a Disability Rights Commission which teaches the country why the legislation was needed. Because that's a fundamental gap here. People, they'll never know what the CRPD said unless there are actually advocates and they're using it as their kind of Bible. But the general public needs to understand why disability is a rights thing. And so we had a Disability Rights Commission that saw his role as educating the people of Great Britain about it, as well as bringing in key players and refining the law in terms of how it was implemented through regulations, because the regulatory framework at that level is another opportunity to kind of get the teeth built in.
Thank you so much, Susan. Carla, back to you. You mentioned already some of the principles that the Canadian Accessibility Act was built on. I'm sure a lot of regulators in the room that also hopefully are working now, would want to start working on something similar. What would be your key recommendations on top of everything that you already underlined already, working with the community, nothing about us, some really practical, tactical stuff?
Oh my goodness. Well, I think knowing where you're starting from is a very important thing. So knowing what existing laws, what policies you have in your current toolkit. And so how are you going to, what gaps exist? I actually want to lean into the nothing without us piece because I don't think it is such a fundamental success point in Canada's story. Like I can say without hesitation that without the very clever and sophisticated push and pull of the disability community in Canada, we would not have the Accessible Canada Act. Like it is, we could say, thank you, Carla, for your leadership, and I would appreciate that, but I can guarantee that without the kind of strategic advocacy and putting, your thumb on the pressure point when you needed to put the thumb on the pressure point, and in Canada, we've actually moved to nothing without us, this kind of truncated version. What we found within the disability rights space for a very long time was nothing about us without us was interpreted as somebody performs a gatekeeping function to decide if something is about you. And then if we decide it's about you, then you're invited to the table. And so kind of moving to nothing without us was a very symbolic and very loud and clear symbol that everything is about us. And there isn't a decision a government makes, there isn't a policy a government doesn't put in place that doesn't impact the lives of people with disability. Like I could play a drinking game with any of you and tell you exactly how every single law in our country applies to people with disabilities. And happy to do that. And it was this kind of, and I'm gonna use a sport, there's this TSN turning, we have a sport broadcaster in Canada where the TSN turning point, like when was the moment in the game when it kind of tipped? And when we started talking like that, that was one of those moments where it became very clear. And when the government started using that language, when I started using that language, it sent this signal that there will no longer be a gatekeeping function performed here. If we are doing a national housing strategy, you're got to be at that table. If we are doing, a COVID response, we need a specific disability advisory committee. Like there is just, and to Susan's point about having a disability commission, I mean, for me being that minister at, in cabinet, to kind of every single time an MC came or every single time a conversation, it wasn't just that the disability minister was responsible for everything to do in the whole country around disability. The transport minister was responsible for accessible transport, and my job was to make sure they knew that. And the housing minister was responsible for accessible housing, and my job was to make sure the minister knew that. And like, in addition to doing the work, kind of the disability-specific work, we needed to take a horizontal disability lens approach to government decision-making. We're not there yet. Like, I'm making it sound like we've got it all figured out. We sure as heck don't. But like, philosophically, we're moving to a world where we're trying to get the message across that every single decision that is made impacts us. And we are not apologizing for that. And I think that's the big takeaway, is like really strongly understand that governments don't get to decide what is or is not about you. everything is about you.
Thank you. Just let me ask you two clarifying questions. You mentioned the phrase, and I hope I remembered right, the thumb on the pressure point. In this discussion and in this process of getting this together, what is a thumb on a pressure point? Give us an example of what this means in practice.
Well, I mean, we're all friends, so we are absolutely all friends. So one of the challenges, and we can talk about how this came to be within the disability community in Canada, and I suspect it's this way elsewhere, is people are so busy and organizations are so, under-resourced and have so much on their plates that there isn't a sophisticated lobby, a disability lobby in Canada. Everybody comes to a minister with their own issues or comes to a different, like there wasn't before the Accessible Canada Act, there wasn't a coordinated lobby in the country around disability. Everybody wasn't on the same page as to what the priority should be, and most people were so busy surviving and just delivering for the people they served that there wasn't like a slick PowerPoint that people could, like there just wasn't the capacity within the community. And we provided some resources, but there was the disability community came together behind the Accessible Canada Act and decided that this was the one thing we all agreed upon we needed to work together to get done, and it was magical because every community in our country, all 338 constituencies or ridings, have organizations for people with disabilities, and all of a sudden they were all going to their MPs and saying the exact same thing across the country. And so there was this real kind of synergy within the disability movement around getting this across the finish line. And when that happened, and everybody was hearing the same thing, it was opposition parties were hearing the same, the Prime Minister's office was hearing the same thing, the things you saw on the news was about this thing, it couldn't be ignored. And politicians, we didn't get to say, well, that's not what I heard from the last group. I heard that this was a priority, and so they got to get their shit together before they come and we help them. But no, it was this unapologetic, very coordinated effort to put this as the thing that government needed to do, and it was very, very impactful. Like and I did work a little behind the scenes and maybe suggested the things they might want to say to a minister to get a minister to jump a little bit higher. But I was very proud of the community because they came together, and without that coming together, we wouldn't have got this across the finish line.
Michael, can I come in?
Susan?
And I just want to add, because that's a brilliant story, we saw that in the 90s when we were working up to the Disability Discrimination Act in the UK, and then that community went back to being separate. Really important. That's why that Disability Rights Commission, bringing that community along, how do we make this thing really work and so on, becomes crucial. The 5 years after are as important as the run-in to get it up and running.
Thank you. Another remark that I made in my head is when you spoke, and this is then also the segue to the both of you, you said make sure that the transport minister knows. Of course, you can send him an email and then he knows, but you mean something different. And it also means that not only the transport minister knows, but all the transport companies know. No? What did you do so that the transport minister knows?
Right. Well, I mean, at the beginning, so during the consultations for the Accessible Canada Act, we had consultations with the disability community across the country, but we also had sector-specific consultations in areas of jurisdiction of the federal government. So transport would have been one of them. So we had a dedicated effort to have the people, Susan, you were talking about at the table, the people who were the Air Canadas, and not the lawyer for Air Canada, but the HR person for Air Canada or the chief technology person for Air Canada, because Air Canada, you're going to be the one to actually have to live up to this. And so we did sector-specific consultations within kind of the purview of the federal government, because we're a federated country, so there's things the government of Canada doesn't play in. And now I've completely lost the question. I was so excited to talk about that part of it. But
it was about how to make sure that the minister knows.
Okay, yes. So that also involved a very stubborn and persistent champion within cabinet. And that's just the bottom line. Like, we don't currently have a Minister for Disability in Canada, and it is noticeable. And that's just how it is. With no disrespect to my former colleagues, there's something very pragmatically important about having somebody at the table, or being in question period and a accessible transport question comes up, and the whip looks at me and I'm like, that's not for me, I'm not transport, that's the transport guy. But there's just having that person is just a thing that we needed at the time. I think it's the thing that we still need in Canada. I mean, I'm not running the country at present, so I can't make that decision. But it is really important to have a champion. And I can tell you, as the person that filled that role, it's a very heavy burden, because you know, and you all know it, every table that you're at, that if you weren't at that table, if you weren't sitting there, they wouldn't be having this discussion. And it feels very lonely at times to kind of carry that for the people you're trying to help. But it is incredibly important. And when you pull it off, it's pretty awesome.
Thank you, Carla. We got 70 minutes and 31 seconds left, so I would like then to make a closing round with the three of you. And ideally, if you have some recommendations for the audience in what avenue to take, what decisions to make all actors of society more accountable. Who wants to start? Oliver, Susan.
After me, everyone says. All right. I think we underestimate the importance of the tabloid press, social media, the ordinary human being on the street who is a not yet disabled person who's got a disabled brother, mother, lover. We've got to get further out, making it harder for a transport minister to ignore us, because actually his wife, mother, lover is raising it because she just read it in The Sun, right? We've really got to focus more on telling the world that this is a human right, not a some human rights. And that when you are denied access, it's an inaccessible piece of kit. It's I can't get a job. I can't get anybody when I've lost my card, my credit card, and I'm traveling and I'm deaf, and they won't talk to me except between 9 to 5, even though if I was fully hearing, I could talk to somebody 24 hours a day. Isn't that discrimination, or is that just inaccessibility? So I think we need to really focus on making the link between accessibility and life chances being denied much more clear. And for me, it's the kind of thing that the tabloid press would pick up if it was presented to them properly. I did some research 100 years ago for Amnesty International in the UK, and they were really unhappy to discover that it was readers of The Sun who resonated more positively to their messages than readers of The Guardian. They didn't want to hear that. They got rid of the committee that found that out. Really, they apologized to me 5 years later. Now, the point being, we need to really change the assumption that it's only the disability community that's fighting for this stuff. And I would say we need to do, as Carla's been saying, get some consistency in the messages. What's the standard? What's the adjustment? Because if you do go down the standards route, so the standard is this glass is going to look like that, well, then we're partway on accessibility, and then somebody comes along who needs to have it with an extra handle, right? You don't want to stop that. You need that balance. And that's where the standards and the regs and this word reasonable really come into play. But first we need to get past that big message that this is just about some, and I have never met any of them, and it's not that bad really.
Thank you, Susan.
They agree. You see, people agree with me. I must be right. They agree with me.
Like we all do all the time. So. Oliver, your recommendation-based...
Thanks very much. Carla, it was so interesting hearing you describe the functioning of the government and the governance structure in Canada, and just a lawyer's reflection is that that's a great example of what the CRPD requires all countries to do in Article 33, that there's supposed to be a focal point in government to do exactly what Carla was talking about, which is not just be in charge of implementing the rights in the convention and under domestic law, but badgering the Minister of Transport, the Minister of Housing, etc., and doing that mainstreaming function So that's required in the CRPD, but I would wager that in the vast majority of countries in the world, it doesn't really happen like that. So that's something for advocates to look at. I'm very interested in accessibility of the justice system, because without access to justice, we can't fully, as has been said, we can't really say that rights exist. They might exist on paper, but the only way to narrow the gap between rights existing on paper and rights discussed in conference rooms here in Vienna or at the UN headquarters in New York or in Geneva is to bring rights home. And the main way that that is supposed to happen is through legal challenge and by activating the judiciary so that rights can actually be enforced. And that's very, very difficult to do if there's no practical means in a country to do that. So it's one of the big challenges in these times of austerity and cutting back and shrinking and in some cases the dissolving of civil society space, is to try and advocate for legal aid so that people with disabilities can bring cases to challenge rights violations so that those rights can be remedied by the judiciary. And it's far wider than the CRPD talks about in Article 13 about access to justice, which that's really talking about the reasonable adjustments that are required within the justice system. You know, so making sure that age or procedural accommodations are put in place if there's a disabled witness in a trial, for example. That's great, necessary, but that's not going to bring about whole-scale reform, because that doesn't talk about accessing the justice system so as to implement other more substantive rights in the CRPD. So I think that's a huge problem in many countries, in many high-income countries, including the UK. That, for me, that would be a focus of advocacy efforts.
Thank you so much, Oliver. Carla, what's your final recommendation and your final request for the homework for the audience?
Perfect. First of all, I want to put a plug in for political participation, because I think that, you know, our story in Canada is not yet finished. If I'm obsessed with political mobilization right now, I think that within Canada, within other countries, the disability community, you know, could be a voting bloc, like a significant. I think the political party in our country that figures out that this is someone to whom, some group to whom we should be pandering, for lack of a better word, during an election. You know, 27% of Canadians. If one or two people loves that person, you've got 50 to 75% of voters who are interested in what you have to say about disability. And yet, political parties in Canada anyway don't court these votes. I don't understand it. I couldn't get my political party to kind of jump on it. Like I said last night, one sentence in a platform. But I think if the disability community could somehow politically mobilize and influence, there could be an election influence there just because of the numbers, right? So I'm really thinking hard right now as to how we can in Canada test that from the other side, right? You know, I couldn't do it from the inside within a party, but like I'm wondering what we can do, you know, and I've got my ideas about this, to really mobilize politically the disability community. Again, kind of like we did around the ACA, but to influence not only platforms, but election outcomes. Like, we've got the math. Around the world, we've got the math. So we got to figure out how to use that math to advance disability rights, to advance disability issues, to kind of put a stake in the ground, because we're not going anywhere. And that's just a fact.
We're not going anywhere.
Thank you, Carla. So it's for me now to wrap up this incredible session. We started with human rights and legal rights. We're ending up with telling the audience, giving them the homework. There's so much more that you can do if you just believe in yourself, and if you stick together, you can basically achieve much more than all of you think individually. Please join me in giving my fellow panelists a warm applause for this very good panelists. Thank you. Excellent, thank you. So this concludes this final panel of the Zero Project Conference, and I'm handing over to my colleagues who will start now the closing session of the conference. Thank you.